Okay, we're back on to contracts, the second half. All right, we'll try to make this as short and sweet as we can. Since you got 2 lectures, let me share my slides again. All right, so we're back on the second half of lectures. This is chapters 10 and 11. So, whoops, okay, so I've called it contracts and basics, but it's chapters 10 and 11 basically. So there's several different types of contracts that are mentioned in your text. And I want to talk a little bit about them. There are express contracts, which are when the terms are expressly or explicitly spelled out. Implied contracts, which are inferred from the actions of the parties. And then there are quasi-contracts, which are implied in law. And these are contracts that aren't either spelled out or inferred from the actions of the parties specifically, but it's where the law says that it's going to impose a contract. It's going to say, the law is going to say that there's a contract to avoid unjust enrichment of one person at the expense of another. So let's say one party has benefited from something and doesn't want to pay the other party for whatever it benefited, the one party benefited from. The law is going to say, you know what, you benefited. We're going to say there's a contract and you need to pay the other party the fair market value of whatever your benefit was. Mutuality is a big issue in contracts. There are bilateral contracts, which is just what it sounds like, bilateral, meaning both parties. Each of the parties makes a mutual promise. So I agree to do this if you agree to do that. I promise this, you promise that. You agree to feed my cats. I have 3, by the way. In exchange, I agree to pay you $10 a visit. Unilateral contract is one party performs an act in exchange for the other party's promise. So it's a promise in exchange for performance. So I put up a poster offering a $100 reward for finding my lost cat. You find my cat and you bring her to me. So I offer the promise, I promise to pay $100, and you do the action. You bring me my cat. My one cat, Macy, she's always getting out. People always want to bring her to me, but she's not lost. She's just a wanderer. So she's my newest cat. All right, enforceability. There are some contracts that are void because they lack one of the 3 legal elements, or one of the 5 legal elements, really. Remember, the big 3 are offer, acceptance, and consideration, but the other 2 are that there must be capacity by the parties entering into the contract, meaning they must be of legal age, they must be mentally able to enter into a contract, they must not be intoxicated, etc. And the contract must be of a legal subject. And then there are voidable contracts. A voidable contract means that the contract is legal on its face, but perhaps one of the parties has a reason that he or she may void the contract at their choice. So examples of each of these, a void contract would be one where there's, for example, no consideration. It's lacking that element of the contract, so it's void, it's no good. A voidable contract would be one where, for example, somebody is a minor and they've entered into a contract. They're 17, which is not legal contracting age. They've entered into the contract. That minor, if they so choose, they've changed their mind, can decide that they don't want to be in that contract anymore. And they can say, yeah, I'm not going to honor the contract. And they can walk away. It's voidable at their choice, not at the other person's choice. If I have entered into a contract with a 17-year-old, I can't say, oh, you're 17. I'm not going to honor this contract. I'm bound by it as long as the 17-year-old continues to say, I want to stay in this contract. Only the 17-year-old can decide that they want to make the contract null and void. And if the 17-year-old turns 18, they have a reasonable amount of time to then decide they don't want to enter into the contract. Once they enter that age of majority, if they continue to act upon the contract as a valid contract, then it will become a binding contract upon them like an adult. All right, this is just some terminology. I'm not going to read these to you. You can read these, but we like our ors and our es and our ers and our es in the law. So just keep that in mind. Remember the offeror, the promisor is the one doing the thing, and the es are the ones receiving the thing. So offeree receives the offer. Transferee receives the transfer. All right, let's talk a little bit about assent. We talked about it a little bit in the last lecture, but we're going to talk about it in a different context here. There are times that there is assent, but it is not made entirely voluntarily. So for example, somebody may do something under duress. And I gave you what I thought was sort of an interesting little movie clip video on the website, and it was not a movie I've seen. I just thought that the trailer alone gave you that feeling of duress. So there's two types of duress. There's physical duress, which we saw a little bit of in that movie when he gets, slapped around a little bit. Physical duress is the threat of bodily harm. You can think if somebody's holding a gun to your head saying, sign that contract, that's physical duress. If you sign that contract under that kind of physical duress, it results in a void contract, if you can prove it, of course. And then there's duress by threat. The victim feels like there's no reasonable alternative but to agree to the contract, and that creates a voidable contract. So maybe you felt like you were under duress to sign the contract, but later on you agree it was a good contract to enter into. It's not void. It's voidable at your choice since you were the one under duress. So those are two different things. So the book, I think, gives some good examples of this. But the three elements of duress by threat are: the threat must be improper. So the threat, it can't be a threat if, for example, you're signing a contract for a loan. The threat can't be if you don't sign a contract for this loan, you're going to lose your house. If that's a fact, it's not a threat. So it has to be an improper threat. It has to be, if you don't sign the money for sign the papers for this loan, I'm going to break your knees. That's improper. So there has to be no reasonable alternative, right? So, there has to be no reasonable alternative. And the test for inducement is subjective. So you have to feel threatened, you or whoever's entering into the contract. It doesn't mean that I would feel threatened in the same circumstances, or that the person sitting next to you would feel threatened in the same circumstances. Did the person signing the contract feel threatened at that moment in time? So it could be somebody very meek that was threatened easily. Could be somebody who was young and just didn't understand the circumstances and got flustered very easily, that kind of thing. So your book did, I think, a good job explaining using Jack and the car salesman, which was not a call out block or anything, but it was in the paragraphs on page 214, and gave some good examples of Jack buys a car from a car salesman and it turns out to be a lemon. And he wants the car salesman or the car dealership to buy the lemon back from him, the car that is no good. And it says, if he goes back to the car dealership and says, you buy this car back or I'm going to break out every window in this place. Well, that's duress. And so that would result in a void contract, because that's, if the car dealership believes that he will actually do that, that's duress and creates a void contract. If he finds out that the car salesman or the car dealership is tampering with odometers, rolling them back to make it look like the cars have lower mileage than they really do, and he says, you buy this car back or I swear I'll have you federally prosecuted for tampering with these odometers and I will narc on you in a second. Is that duress? Well, yeah, it is, if they believe that he'll actually do it. So even though they're doing something wrong, the dealership is doing something wrong, and even though this is a sort of a whistleblower thing, it's not necessarily his place, but because he's trying to get personal gain out of doing this, it's duress. So the contract would still be voidable. So if he decided to go do that, that would be a good citizen thing to do, but not if he's doing it to get them to repurchase his car. And then the final choice was if he says, you better repurchase this car or I will haul you into court and I will sue your butt. Is that duress? Well, no, because that's his right as a citizen, to go haul somebody into court. That's what he can do. So he may say it nasty, he may say it nice, but it's not duress. So just some good examples, I thought, in that particular paragraph. Undue influence is another area. You may have somebody giving undue influence for entering into a contract, and that's unfair persuasion. And I always sort of think of like a parent and maybe their child buying their first car or first house or something like that. But this is improper use of trust or power to deprive a person of free will and substitute another's objective. This is where the victim's under the domination of the persuader and believes the persuader will act in a manner detrimental to the victim's welfare if the victim fails to assent. So this could be, I don't know why, but I always think of a helicopter parent who's saying, I know what's best for you, sign this. I know what you need. Or a older person married to a younger person or something like that. This can result in a voidable contract if indeed it's undue influence. But it can also be a situation where it's, you go in for a salesman and they're like, I know what you need. Just don't worry about it. Don't worry your pretty little head. I can tell you what you need, which is how I always feel when I go to car dealerships. They drive me nuts. Misrepresentation, obviously, is a statement of fact that's not truthful. It can be intentional or it can be unintentional. There are different types of fraud. There can be fraud in the execution. They give the example of, we're going to enter into a contract. And so I show you the contract. You're like, okay, that looks good. But before you sign it, I slip a different version of the contract in front of you to actually sign. That's fraud in the execution versus fraud in the inducement, which is misrepresentation about the subject of the contract. So I show you a picture in class of a silver BMW and I say, hey, anybody want to buy my car? I'm going to sell my car. It's time for me to get a new one. Anybody interested? And you say, yeah, how much are you selling it for? I'm like, yeah, I'm going to sell it for 10 grand. It's a 2012. It's got 75,000 miles on it. And you're like, yeah, I'll totally buy that, and so we sign a contract, we exchange the money. I'm like, I'll drive it to school. We can do the exchange in the parking lot. And when you come out there's my Toyota Camry. And you've just bought yourself a Camry, not a BMW. So that would be sort of fraud in the inducement, where I tell you it's one thing, but it's really something else, which is what I drive, by the way, a Camry, not a BMW. Fraudulent misrepresentation has to have three elements: misstatement of fact, intentionally made misrepresentation, and reliance. So these are some different types of misstatement of fact. Concealment. So concealment might be, I didn't mention the fact that I totaled my car 3 times and had a lot of work done to it. Or I've concealed, I painted over, like they use the example of painting over flaws in a building. That's probably a better example. Non-disclosure would be not telling you that I've totaled my car 3 times. That's why we have things like the Carfax and that kind of thing. Statements made false by subsequent events. So, I tell you, my car's never been in an accident, but between the time I tell you that and the time we contract, I've actually had an accident in my car. Statements of opinion, I get that's sort of self-explanatory. Misstatement of law, and then assertions of intention. So I gave you some examples here. I'm going to let you sort of figure out which ones are which. Just sort of some examples that you might try to match up with the different areas. Non-fraudulent misrepresentation are maybe negligent, maybe misstatement of fact, materiality, and justifiable reliance. So negligence, we know what that is. That's where you do something, but you don't do it well, you don't do it properly. So it's sort of sloppiness. Misstatement of fact, and we've just talked about, it's where we don't state everything properly, either intentionally or unintentionally. But this is non-fraudulent. This is where we've stated something just because we didn't know or we didn't have the full story. Materiality has to do with, when we say something is material, we mean it's important. So this has to do with how important something is. We've made a misrepresentation. Is it a material misrepresentation? Means, is it an important one, or is it something minor and really not critical? And justifiable reliance means, did you rely on it? Was it an important factor in the decision? All right, let's talk about mistakes. And I like this because this gets us to the good ship peerless, which is was one of my favorite cases to study in law school. Unilateral mistake is when one party makes a mistake, rendering the contract voidable. They can't take advantage of a known mistake unless the negligent party would suffer unconscionable hardship. But this is where one person's made a mistake, the other person knows what they're doing. Mutual mistake is when both parties are wrong about the subject of the contract. So that's when it has to be a basic assumption on which the contract was made. It has a material, again, an important effect on the agreed exchange of performance, and the party seeking relief doesn't bear the risk of the mistake. So let's talk a little bit about capacity. We'll come back to the good ship peerless in just a minute and mutual mistake and what that means. When we're talking about capacity, as far as minors, and they call them infants if we're talking about people under 18, don't be offended by that if anybody's still under 18. There are exceptions to generally a contract with a minor, somebody under 18, is voidable at the option of the minor. There are some exceptions. So if a minor enters into a contract for what we call necessities, a contract for food, for a roof over their head if they have no place else to live. So they don't have parents, they don't have a home to go to, and they rent an apartment and they need that apartment. Those kinds of things, then that contract is not voidable. That's considered because it's a necessity. There are certain contracts that are non-voidable just by the nature of the contract. If the minor misrepresents their age, if the minor ratifies the contract, again, once they become 18, they ratify the contract and act as though they want to continue the contract. They have a duty to return consideration received if they decide to void that. And if there's a tort connected to the contract, then they're treated as though they have capacity as an adult. If they're mentally altered, so intoxicated, high, that sort of thing, if they're mentally ill. So mentally ill, a contract is voidable by people once they regain sanity. So if they are temporarily insane, or by the guardian. And again, you have the exception for necessities. So if a mentally ill person, again, rents an apartment, orders food from Hungry Root or Home Chef or something like that, and they need that food to live, then that contract is valid, not necessarily voidable. Intoxicated persons, and I think this is kind of interesting, especially given the Lucy versus Zimmer case that we talked about in chapter 9. Intoxicated people, and this is maybe important to know as a college student. If person A is drunk and person B knows person A is drunk and tries to get them to enter into a contract anyway, there's no contract if you know somebody is drunk and you try to get them to sign something. So don't do that. If person A is drunk, but person B has no idea that person A is drunk or high, then there may be a contract. So if you're one of those drunk people or high people and people can't tell, you may find yourself entered into a contract. So if you hold your liquor well, be careful, don't sign anything. If person A is partially drunk but has some understanding that they are entered into a contract, then there probably is a contract. And that's probably what we had in the Lucy versus Zimmer case, the real estate case, written on a cocktail napkin that we talked about in chapter 9. Unless there was no consideration or there's something else abnormal about the transaction, there probably is a contract there. So this is where we get into the good ship peerless. It's actually not that case. It was actually the Konic International Corporation versus Spokane Computer Services case. But in this case, we had the situation where somebody from the computer services company orders what was it, a surge protector, and the salesperson said, okay, that'll be $56.20. And the guy was like, great, writes up a purchase order for $56.20, sends it through, installs the surge protector, no problem. Turns out surge protector actually costs $5,620. So this was a mutual mistake where the parties didn't understand each other. So it was a mutual mistake. And of course, there was a dispute now. Did we have a contract? Because we each had a different price in mind. And so the judges pulled up the good ship peerless case, which again was one of my favorites to study in law school. In the good ship peerless case, and that's how it's referred to, the parties agreed that certain goods would be shipped out from Bombay on the good ship peerless. Well, it turns out there were two ships named Peerless, and each party meant a different one. And so they drew on that old case about the good ship Peerless. And basically what it comes down to is if the parties are talking about two different things, if they have a mutual mistake of a material fact, there can't be a contract. The contract is void. So there's no binding contract if you have a mutual material fact that you misunderstood. So anyway, it's kind of an interesting sort of thing. If it was a minor mistake, like I said I delivered on Tuesday and you said you delivered on Wednesday, probably not material, probably not that important a fact. But this kind of price, that's pretty big. That's a pretty big and material difference. All right, let's talk a little bit about consideration. Consideration, again, is the value for the bargain, basically, the benefit of the bargain. So what the promisor receives for benefit, and the promise gives up something. So it can be something you agree to do, an act. It can be something you agree to give up, a forbearance, or it can be a promise. So it can be, I'll give you $10 if you agree to wash my car. That's an act. It can be, I'll agree to give you $20 if you quit smoking by the end of the semester. That's forbearance. That's something you agree to give up. It can be, I promise to stop yelling at you in class if you agree to stop sleeping in class. So a mutual promise. The elements of consideration, what you're looking for is, has the promise incurred a legal detriment, given something up, and was the legal detriment bargained for? Did the promisor specifically intend the act, forbearance, or promise something? Basically what we just said. I should take that slide out. And then these three things sort of give you this is sort of a test to see if you can identify which one has consideration. Betty offers to give a book to Lou. Lou accepts. Does that have consideration in it? Number two, Betty offers Lou the book in exchange for Lou's promise to pay $25. Lou accepts. Betty offers to give Lou the book if Lou promises to pick it up at Betty's house. Lou agrees. All right, so in all of these, Betty offers and Lou accepts. But which one actually has consideration with it? Well, the reality is only the second one has any consideration. Lou's going to pay $25 for the book. It's not the consideration has to be money. It's just that in the third one, Lou agrees to pick it up. That's really just a term of exchange. It's not that Lou's giving up anything. It's not that he's, going into any kind of detriment. That's just how the product is being exchanged. So anyway, so that's our other lecture. I hope that was helpful, and I will see you all next time.